Jeffrey Epstein is back in the news, and once again the promise of truth and justice seemed to hang just beyond our reach. Earlier this year, Attorney General Pam Bondi boldly stepped before the cameras, promising clarity and justice as she unveiled what she called Phase 1 of the release of the Epstein files. But just recently, President Trump defended Attorney General Bondi and asked the public to let her do her job, and explained that people shouldn't waste time and energy over the Epstein files, client list, or even Epstein himself, the man who just won't die. As a constitutional litigator who spent years decoding complex cases and official doublespeak, something about the Epstein scandal has never quite added up for me. Today, I'm going to take you through a series of overlooked clues, legal breadcrumbs hidden in plain sight, to see if they lead to answers we've all been denied. We'll work through 3 clue sets to do so, and I personally think the second clue I spotted is the strongest in unraveling all of this. Behind the frustrating silence around Epstein's infamous client list, could a secretive legal mechanism be at play? What if the reason for all this secrecy isn't a cover-up, but precisely because the wheels of justice are silently spinning? Let's examine some of the clues that I think suggest hidden grand jury proceedings are still examining Epstein's accomplices right now. To get us up to speed, in July, the Justice Department publicly closed the door on further disclosures of the Epstein files. A DOJ FBI memo announced that no additional Epstein records would be released, stating that no further disclosure would be appropriate or warranted. The memo's big takeaway was that a thorough review revealed no incriminating client list and no evidence Epstein blackmailed prominent individuals. In fact, officials concluded no further charges are expected in Epstein's case. Investigators did not uncover evidence that could predicate an investigation against uncharged third parties. This left most of America unsatisfied. Rather than jump into the political rumor mill, let's get down to the brass tacks of the law and get some legal clarity here. One big clue lies in court filings related to Epstein's case from responses to Freedom of Information Act requests, FOIA. These dry legal documents contain breadcrumbs most seasoned litigators would spot. Let's go back to 2022. The FBI faced a FOIA lawsuit seeking all records on Epstein. The FBI's response was telling. It confirmed that Epstein's case file was compiled not just for Epstein himself, but for other individuals of investigative interest. In fact, the FBI declared that even after Epstein's death, its investigation was ongoing because it included potential co-conspirators. The FBI invoked FOIA Exemption 7A, which shields records related to pending or prospective law enforcement proceedings. Why? Because releasing certain documents, the FBI argued, would provide criminals with information about the government's investigation and enforcement strategies in ongoing matters, and let them identify or tamper with witnesses or otherwise destroy evidence. The FBI explicitly warned that disclosure would harm at least one active investigation and any prospective prosecutions of Epstein's potential co-conspirators. Think about that. By late 2022, the federal government acknowledged in court that it had active investigative matters and possible prosecutions related to Epstein's crimes. By law, such matters, likely grand jury investigations, are conducted in strict secrecy. Grand juries are used to gather evidence and testimony to decide charges, and all participants are sworn to silence. Any materials from those proceedings are protected by secrecy. In the FOIA case, the FBI indeed withheld grand jury materials, names of subpoena recipients, records obtained via subpoenas, precisely because revealing them would violate the secrecy of grand jury proceedings. As we all know, the wheels of justice turn slowly, and when the feds are involved, even more slowly. After all, even after Epstein's arrest, it took about a year just to arrest his closest associate, Ghislaine Maxwell. It's also feasible that early investigations in 2022 led to other fact developments and potentially still other cascading sets of grand jury inquiries. If such grand jury proceedings are still ongoing, the government's forbidden from releasing information about them. Prosecutors can't reveal who might be a target or what evidence they're reviewing. That could sabotage the case and violate secrecy laws. This would perfectly explain why no client list or other Epstein file has surfaced from official sources. Even if agents have identified some of Epstein's associates or customers in evidence, they cannot publicly name uncharged individuals. Now, you might wonder, if secrecy rules are so strict, why would officials even hint at releasing these explosive names publicly? The answer is simpler and more human than you'd think. Ego, ambition, and a burning desire to appear as champions of justice can tempt even seasoned officials into overstepping, only to be reined in later by the harsh realities of the law. Public officials caught between intense public demand for transparency and the ironclad secrecy of grand jury proceedings sometimes stumble, leaving tantalizing hints before retreating back behind the veil of legal silence. Usually after experienced counsel remind them they really can't divulge information the public wants so badly. But there's a second clue set I find most intriguing. Media organizations and groups like Judicial Watch have been suing for Epstein records. The DOJ's behavior in these cases has been oddly conflicted. Publicly, they've stated case closed. Yet in a July 2025 court filing, in response to a FOIA lawsuit, the DOJ told a judge that it and the FBI were continuing to search for and review Epstein records for potential public release. In other words, in court, the department said the search is ongoing, even as its press releases to the public said no more files exist to release. This could indicate that officials are still sorting out what can be disclosed without harming any active investigations. It's almost a wink to the court that we haven't dumped everything yet. If everything truly was done, one would expect the DOJ to simply release all non-sensitive files, or at least respond fully to the FOIA requests. Their reluctance or slow walking suggests there's something in those files that remains sensitive, possibly evidence pertaining to uncharged individuals or open inquiries. This is one of the strongest inferential clues available, that grand jury proceedings are ongoing. Even attorneys for Epstein's victims see the unfinished business in those unreleased documents. Sigrid McCauley, who represents several survivors, stated publicly that the government is sitting on a treasure trove of information, and they're not turning it over. She noted that in over 10 years of working these cases, there's a plethora of information that the public has not been able to see relating to Epstein and his co-conspirators. Her choice of words is key: co-conspirators. McCauley is saying there is evidence on others in those files. She and other victim advocates have been adamant that Epstein could not have run this operation without the help of many people. None of those people have been prosecuted. This again underscores the gap between what's known behind closed doors and what's been done in court. The logical inference is ongoing investigations exist. It's also curious what the Attorney General released in Phase 1 of the Epstein files. The DOJ redacted parts of documents that had already been public before, erring on the side of secrecy. This cautious approach implies that some content in Epstein's records is being shielded for a reason. What's that reason? Does the DOJ wish to act above board and simply avoid salacious gossip? Or is it because those details relate to people who might yet face legal scrutiny? A seasoned litigator might suspect the latter. When prosecutors intend to pursue someone, they often keep a tight lid on evidence until charges are ready, to prevent defense teams from getting a heads up. So the volume of unreleased evidence, the careful redactions, and the DOJ's guarded and seemingly inconsistent court responses all point to information being protected, possibly for use in future proceedings. These breadcrumbs strengthen the theory that something is happening behind the scenes, even as officials publicly dismiss the idea of a client list. Our last clue centers on legal gamesmanship. Even journalistic and independent analyses of the DOJ's announcement suggests we shouldn't take the no client list line at face value. The DOJ's memo was carefully worded to say no incriminating client list was found. Legally, the phrasing is oddly specific. As the Bulwark pointed out, no incriminating client list could simply mean there's no single document literally labeled as such, and not that Epstein's files contain no evidence of clients or accomplices. In fact, Epstein kept lists of many things: phone directories, flight passenger lists, visitor logs, and lots of names are in those. The DOJ might be parsing words. Perhaps the evidence on others exists, just not in the neat form of a list explicitly titled, "Here are people Epstein provided minors to." The absence of an incriminating client list tells us absolutely nothing about what was in the files and could be purposeful use of vague legal language. This suggests the DOJ is technically truthful while sidestepping the real substance. Litigators know this tactic well. Sometimes prosecutors speak carefully to avoid lies, but also avoid giving away anything. For example, if Epstein's files contain, say, emails or messages implicating certain individuals, the DOJ can still say no client list, because it wasn't a formal list. They also couched it with no incriminating list, which begs the question, was there a list they deemed not incriminating? The parsing of this language by observers reinforces the hunch that the Epstein files very likely name names, just not in one simple document, and that evidence may yet be usable if a case can be made. Putting these clues together suggests that there are likely ongoing investigations and grand juries have been impaneled. Grand juries operate in the shadows by design. Neither their existence in a specific case nor their targets can be confirmed publicly unless and until charges are filed. The secrecy serves to protect the investigation's integrity and the reputations of those who might ultimately not be charged. If federal prosecutors have convened grand juries to examine Epstein's network of enablers and clients, it would perfectly explain the public vacuum of information. Officials cannot lawfully disclose any details about those proceedings. They often will refuse FOIA requests by citing ongoing investigations. They issue GLOMAR responses, neither confirming nor denying records exist, and make only bland public comments. We've seen exactly that pattern here. The FBI and DOJ citing ongoing matters to withhold records, and DOJ spokespeople giving boilerplate replies like, "We'll bring justice to victims," without elaboration. Grand jury secrecy would also explain why, from the outside, it appears nothing's being done. Imagine if tomorrow a grand jury in New York indicted one of Epstein's associates, say an alleged client. Then suddenly the indictment would be unsealed and the public would know. Until that moment, however, everyone involved is tight-lipped. This scenario has precedence. Ghislaine Maxwell's indictment in 2020 came out of the blue to the public, even though investigators had been working on it since Epstein's arrest. The same could be happening for others. So the grand jury theory fits the facts in the pattern I've discussed. The government's refusal to release the list isn't necessarily nefarious. It could be legally necessary to shield an ongoing enforcement action. In a sense, the list might be in use as an investigative roadmap rather than a public document. Each name on a flight log or an Epstein's address book might be a thread agents are tugging at, interviewing witnesses about that person, checking alibis, following money trails. This process can take years, especially for older crimes and high-profile suspects with resources to fight back. And if prosecutors determine they don't have a strong enough case to indict someone, we may never see that name officially mentioned. For now, the Epstein client list remains an enigma, perhaps by necessity. The grand jury theory provides a credible, legally grounded explanation for why we haven't seen names named. The pursuit of justice often requires patience and secrecy. Publicly revealing all of the dirty secrets in Epstein's files might satisfy our curiosity, but it could also doom any chance of holding additional perpetrators accountable in a court of law. As frustrating as the wait is, the idea of indictments coming down the line is far more satisfying than a mere shaming list released to the press. In this legal drama, the government's outward insistence that there's no list could be the equivalent of a poker face. The real game is unfolding behind closed doors, in grand jury rooms where jurors see evidence that the rest of us do not. We've read the signs, the FOIA evasions, the sealed memos, the ongoing investigation language, the fact that even in 2025, officials were still reviewing files rather than publishing them. All of it suggests that the Epstein case is not truly over. Until that day, we're left in an uneasy limbo. On the surface, the case seems cold, provoking outrage from the public. Why hasn't anyone else been named or charged? Is justice being denied? But just beneath, if you look carefully at the breadcrumbs, you can imagine the scene. Somewhere, prosecutors are still asking witnesses hard questions, agents are sifting through evidence, and a grand jury may be listening to testimony, all in strict confidence. In the final analysis, this theory holds that the Epstein client list, or Epstein file, isn't missing at all. It's simply locked in an evidence vault marked grand jury. Do not disclose. Only time will tell whether the vault will be opened. If and when it is, the world may finally learn the names behind the headlines, not through a leaked list, but through perp walks and courtroom verdicts. And that, ultimately, would be the most dramatic ending of all. I'm Benjamin Barr, and I'm thrilled that you were with us today. My job as a constitutional litigator is to give you the tools necessary to solve legal and constitutional controversies of the day. I hope that you'll like and subscribe to the channel. It really helps with my educational project. And please join us next week as we explore yet another constitutional controversy.